What's the most obscure law that you've actually used in a case? Story 1. A law professor of mine was representing someone who owned a goose and was being sued by a neighbor because the deed said no geese. When the deed was written, the singular and plural weren't interchangeable. Professor said deed only said no multiple geese and one goose was okay. Judge agreed. Story 2. One I heard from a criminal defense attorney in law school. His client is driving down a country road at night without any lights on. A police officer is parked off the side of the road and, seeing the man drive by, pulls out behind him to follow him, but also doesn't turn on their headlights. Eventually, they pull the man over and find that he has a lot of cocaine in the cab of his trunk. Charges are brought for possession with intent to distribute. They get to court, and the attorney cites the fact that, under the relevant state law, it is not legally required to have your headlights on at night unless there is another vehicle visible within 500 ft of your vehicle. Because the police officer was also driving without headlights, the man had no reason to see them, and therefore, he was legally allowed to drive without his headlights on. Because of this, there was no reason to have pulled the man over. Thus, the discovery of the cocaine was fruit of the poisonous tree, i.e., any evidence that is discovered improperly must also be excluded. Case dismissed. Story 3. Engblom vir Carey is a good one. Long story short, there was a prison workers' strike in NY, and the National Guard was called in to scab. Importantly, the guard was put up in the on-site housing, where the prison workers had been living. Here's the thing. According to the court, the guard are soldiers, and the on-site housing was private residence. As such, the decision to house them there actually violated the Third Amendment. That was the first, and so far only time the 3A was ever the basis of a significant decision, and it wasn't until 1983. Edit Ianal. I just think this case is a good example. Story 4. We read a contracts case back in school that ultimately came down to the issue of whether a hot dog was a sandwich. Edit. Wow, let me go back and see if I can find the name of it. Story 5. I haven't used it yet, but the other day while researching a related issue, I stumbled across a 100-year-old case that said summons served on Sundays were null ab initio. Hasn't been overruled, although it's probably dead letter. If I ever have to dispute a summons that was served on a Sunday, I might pull it out and see how it goes. Story 6. Not a lawyer, but one time I had to sue a landlord who made up some pretend reasons to keep my security deposit. I spent a Saturday in the law library at the local university and found a law that would let me win my lawsuit and claim triple damages. The landlord read my lawsuit and offered to give me my deposit back plus $500. Sweet. Story 7. I routinely cite a 1921 case regarding a forged railroad ticket when I'm trying to argue the best evidence rule of an original that's later been marked up with pen or has some notes on it. The case says that if something is printed out containing all the elements of what it's trying to do, then any handwriting on it is evidence that it's been altered, and the alterations must be shown to be lawful by whomever seeks to enter the item into evidence. Very good to use to keep things out of evidence. Story 8. I didn't, but worked in an insurance litigation firm where a guy used an 1800s maritime law to defend a case that occurred on a boat on Lake Michigan. He wanted to get it out of state court and into federal court, where civil verdicts usually have less value in our area. That was neat. Story 9. My maritime law professor was a glorious and I'll never forget this story, he told. For this, you need to know that below the mean high tide line on a beach is public access. My professor, in his younger days, had just finished the bar exam. He went to the beach. The beach was super overcrowded. Just a short walk down the shoreline was a private beach club. This beach and beach club were right near my college, so I've been there and seen both. The beach at the private beach club was wide open and much less crowded, so he walked down the shoreline and parked his chair somewhere below the mean high tide line. A few people from the beach club tried to get him to leave since he wasn't a member, but because he was in the public access section of the beach, legally they couldn't do anything. Story 10. A client of mine was writing a scathing review of the Australian court system which he intended to publish in a book. When advising him regarding defamation, etc., I ended up dredging up an old Australian law of scandalizing the courts, whereby a person commits an offense if they incite disenchantment or distrust to the extent that it undermines public confidence in the judicial system. Story 11. I don't know if this would be interesting to anyone else, but I drafted an MSJ last year where an insured inland marine trucking company had mistakenly delivered a filled cargo container back to port instead of the client, and it was shipped back to China where it was held by customs and the cargo was eventually destroyed. The insured's policy did not cover mishandling, misdelivery, or misplaced cargo, but provided coverage for all non-excluded losses. They tried to argue that, in misdelivering the cargo, they had lost it and thus, it fell under the policy as a non-excluded loss. It only took them a week or so to locate the cargo on its way back to China, so it was never lost. But they still tried to claim that a loss in an insurance contract included anything lost. Dumb as argument, but the partner took out my entire section addressing the definition of loss, as in to lose, and loss in an insurance context, as in the monetary value of insured property, and we lost the MSJ. I'm thankfully no longer in commercial property insurance defense, but that one really annoyed me because it was such an obvious mischaracterization of the contractual language and such a stupid move by the partner. Story 12. I had to give advice to a public entity about the US flag code. An employee had raised a grievance that the way the flag was hung in a particular room violated the code. Technically, the employee was right. The question was, what kind of remedy was enforceable under the flag code for a violation? The answer? None. Petty, upset employee got no satisfaction. Story 13. Work for a debt collection law firm, and we also do some subrogation work. State of Michigan has a law on the books from back in the day whereby cattle are exempt from liability in automobile accidents. Case involved an accident due to the cattle going across the road pretty suddenly, and there was a car on cattle collision. Guess who got blindsided in court by this law from the 1800s? Story 14. This 13th century legal doctrine has been brought up in several bankruptcy cases I've been involved in. Edit. Okay, I am not an expert in this, so somebody please correct me where I go wrong. Basically, this relates to the golden creditor rule. In most U.S. states, there is a 6-year look-back period for fraudulent conveyance, meaning that if you're a creditor in a bankruptcy and you'd like to seek derivative standing to pursue fraudulent transfer claims, basically seeking the return of assets that the company sold for less than fair value, you're generally limited to asset transfers that occurred within 6 years of filing. But if there is a government entity that's a creditor, e.g., the IRS for taxes or the Treasury debtor seer for unpaid fines, then theoretically those claims are not time-barred because nullum tempus occurret regi. Time does not run against the king. And then, due to some other precedent I'm a little fuzzy on, another non-government creditor can sometimes step into the shoes of the IRS or whoever, and also not be subject to the look-back period. Story 15. Not yet applicable, but in case a no-deal Brexit goes trough, 50 Bruges fishermen can continue fishing in British waters because of charter from 1666. One fisherman already tried his luck, and the British were advised to not pursue the case because most likely the charter is still in effect. Story 16. Obligatory NAL, but I work at a lawyer's office in Germany. One of our lawyers managed to get our client off a speeding ticket by finding out whether or not you needed some sort of specific certificate to be allowed to operate the radar speeding gun. He found out there indeed was some obscure certification of many that is needed and is supposed to be renewed every 2 years or so. The officers who wrote the speeding ticket hadn't renewed theirs in a while. Apparently nobody did, though. Nobody even really knew about that specific certificate. He won the case. The judge agreed they shouldn't have been operating the radar gun without the certification, even though the dude really was speeding. Story 17. I cited a 1500s case from the UK on grave robbing that stated that property can never be ownerless in a dispute over the ownership of a pile of dirt. I also cited a 1700s case on interpreting the rule against perpetuities. Story 18 case sales tax case. Client has to post amount of disputed tax and then ask for the money back before getting an opportunity to sue to get money. There are also interest and penalties. If you do not send a letter asking for the state to not pursue, state can still go after client even though case is pending. On the letter to request the state not pursue at the top must be written in red ink specific words, or the state can ignore the letter per the regulation. This case has been going on since 2006 and haven't been able to file a case yet in court. Also, state never actually has to respond to the request for refund. Story 19. Where I went to school, the conservation law students had to do a paper on if hunting on horseback is considered hunting with the aid of a motor vehicle here in NY. The answer isn't what you think. Story 20. I do remember hearing a story where this guy in Michigan was arrested for underage drinking, but was only a couple of months away from turning 21. He went to court and pulled out an abortion law for Michigan stating that life begins at conception. So, when he asked the judge if this law was still valid, which it was, he then stated that since that was the case, he was technically over 21 years of age and legal to drink. The case was dismissed, and when the prosecutor made a stink about it, the guy said, "Hey, it's your rules." Story 21. When I was in college, a girl who worked at an expensive law firm told me this, and I always wondered if it was true. She said that when Oklahoma passed a new drunk driving law, that they specifically mentioned the breathalyzer machine that the cops had to use, and since it was a new one, most places didn't have it. So if you got a DUI and they didn't use that machine or even owned old ones, you could get it dismissed by saying they weren't compliant with the law and used, or could have used the old ones. She said they had gotten cases dismissed using that argument. Story 22. The legal definition of massage is so ridiculously overbroad in my state that it literally covers getting water pumped up your colon to clean out all the. We have a statute that prohibits certain kinds of car insurance from reimbursing providers for massage. I was dealing with this shady fly-by-night clinic that offered a bunch of bullshit services that didn't do anything. They were really just a massage parlor that pretended to do other to get around the billing issue. So I argued that everything they did was technically massage under the statute. Story 23. I used the statute of bastardy from Connecticut in a brief I wrote in law school. It was a criminal statute that provided the colonial U.S. equivalent of child support. Story 24. I'm no lawyer, but there's a case that took place in the UK court. Her Majesty's Revenue and Customs, HMRC, v. McVitie's. McVitie's make a biscuit called Jaffa Cakes, and HMRC argues that they were a biscuit and subject to taxation. McVitie's argued that they were in fact a cake, and cakes aren't subject to taxation. McVitie's made a bigger version of a Jaffa cake, cake size I guess, and argued that cakes go hard and biscuits go soft. The Jaffa cake went hard, and McVitie's won the case. Story 25. Not exactly a law, but if there's a no deal, Brexit, all kind of old treaties between European countries and the UK kick in. I know some countries are already proactively retracting old treaties to prevent weird or unwanted stuff from happening. Can give sources but can't find them in English this fast. To make things more complicated, French, Belgian, and Dutch fishermen have a lot of boats under UK flag and using UK fishing quota permits, as those were easier to get some time ago. But in practice, they sell their fish on the continental market. How will this hold legally after Brexit? Depends on which old treaties are still active. I found one beautiful example already. Belgians can fish in British waters thanks to 1666 charters. Story 26. Obscure case, but frequently found in tax law to say the taxpayer is allowed to minimize tax liability. The Inland Revenue v. the Duke of Westminster, or commonly known as the Duke. Case is about whether the Duke is allowed to fire his gardener and give him an annual gift in exchange for his services. Nothing changed except now he can deduct tax on the amount. Story 27. Not a lawyer, but always a fan of the $10 million lawsuit that hinges on an Oxford comma. Story 28. When I was 13, I was arrested in Portland for spitting. Apparently, somewhere in their old law book, spitting on the bricks was against the law, and they went with it. Handcuffed, thrown in a car with lights and sirens, I was booked at the station. I could hear my mom screaming at everyone she talked to, armed or not, about how fucking stupid they were. It was one of the only times I felt like my mom had my back. They dropped the case when she started offering interviews to the local news stations, but I still hold on to my citation for a good laugh. This was 19 years ago, for reference. Story 29 NAL. But, in the 60s, my hippie brother was busted for a traffic infraction in Hingham, Massachusetts. While being patted down, he farted in the cop's face. He was charged with a colonial-era law, uttering in public, and fined. I miss him. Story 30. I've cited a 19th century case from the Indiana Supreme Court as persuasive authority to an Illinois court. The defendant was convicted of having with a chicken. The Indiana statute referred to unlawful union of man and beast. The defendant appealed, and his defense was that the dictionary definition of beast was a four-footed cloven-hoofed animal. The Indiana Supreme Court affirmed the lower court with some beautiful language about statutory interpretation. The court was obligated to interpret the word as the Indiana legislature intended, and the court held that Indiana intended to outlaw with animals as a whole, rather than with four-legged cloven-hoofed animals. I use this case, backed with a string cite of more contemporary Illinois cases, when OC's entire argument was based upon the definition of an undefined term in the statute. Story 31. Not a law per se, but a couple times when the other attorney has really pissed me off, and once with a close friend who I feel like messing with a little, I've responded to an essentially unreasonable request, or in the case of my buddy, an eminently reasonable request, by referring them to the reply given in the case of Arkdel Vorif Prestram. No one ever knows what it means until they Google it. Case is below. Reading to the bottom is worth it. Arkell v. Prestram, 1971, unreported. Solicitor, Goodman Derrick & Co. Sus. We act for Mr. Arkell, who is Retail Credit Manager of Granada TV Rental Landed. His attention has been drawn to an article appearing in the issue of Private Eye dated 9th April 1971 on page 4. The statements made about Mr. Arkell are entirely untrue and clearly highly defamatory. We are therefore instructed to require from you immediately your proposals for dealing with the matter. Mr. Arkell's first concern is that there should be a full retraction at the earliest possible date in Private Eye, and he will also want his costs paid. His attitude to damages will be governed by the nature of your reply. Private Eye. We acknowledge your letter of 29th of April referring to Mr. J. Arkell. We note that Mr. Arkell's attitude to damages will be governed by the nature of our reply, and would therefore be grateful if you would inform us what his attitude to damages would be, were he to learn that the nature of our reply is as follows. Off. No further reply. Our edit, formatting, typo. Originally posted on my phone. Story 32. I recall reading a case file once, where a girl was intoxicated and was kicked out of a club. A drunken male sees her passed out in the street, whips out his giggle stick, and puts it on her head and takes a picture. She sees the picture and claims for sexual assault. However, the lawyer argued there was 4 points of sexual assault. Needs to show genitalia, needs to perform an act which humiliates the victim, another I forget, and finally needs to show sexual intent. However, the defense argued the defendant didn't show sexual intent as the picture clearly showed he didn't have an erection, and he was let off the charge. Story 33. I had a competition with my brother, also a prosecutor who could cite international shoe first, jurisdiction for minimal contacts and fair play. I won in a hearing over forcing an out-of-state adult book company to accept a subpoena. Story 34. It's obscure case law, not a statute. A co-worker of mine used a court decision from the 1880s to successfully defend a document someone was trying to invalidate over an issue concerning a notary stamp. The stamp was clear enough to read, but had a slight smudge that the other side argued made it invalid. They were able to keep the document out in an administrative hearing and won the case on that level based on that. We appealed it to district court. My co-worker found a case from the 1880s where the court described a notary stamp smudged in the same way and ruled it was valid. This was the only case she could find that addressed the issue. Based on that precedent, the district court overruled the administrative court and reversed its decision. Story 35. About 5 years ago, the managing partner of my Chicago firm made me write a motion for a writ of mandamus in a federal case we'd filed in California. The judge generously denied my motion without making me fly out to defend it in front of her. Story 36. R.V. Brown, 1993 is one I use all the time in essays. Second wire student, involving actual bodily harm, ABH, like bruises or broken ankles. Basically, a group of men got together for and put fish hooks through each other's foreskins and spanked each other with stinging nettles. The moral of the case is you can't consent to ABH unless it's things like professional tattoos, piercings, or sports. I'd be pretty mortified having my personal life aired out in public, let alone becoming a significant case in UK law history. Story 37. I am waiting for a chance to use my state's laws regarding proud bitches. One statute requires bitches to be confined while proud for a certain period of time. Another statute provides that there is no liability for killing a proud that is not properly confined. Obviously, this refers to female dogs in heat, but the term proud is not defined anywhere in the state code as it relates to bitches. Story 38. Not an attorney, but I represented myself when charged with possession of an illegal substance, psilocybin aka mushrooms. I found out that in Florida, mushrooms were never explicitly listed as an illegal substance when the law was written, and it hasn't been edited. Sale is illegal, but possession is not. The judge and prosecutor didn't even know about the law, but it had multiple legal precedents. Story 39. In its entrance application, the National Sheepdog Association, which sponsors the annual National Challenge Sheepdog Trials, requests the name of the animal that would compete. And so it was that Farmer Hoggett was able to honestly answer pig. When confronted with the indignation of the competition's judges at the enormity of his porcine entry, Farmer Hoggett's defense was simply, there's no rule. The judges had to concede that there was, indeed, no rule precluding the little pig from competing. And while the announcers and crowd were bemused at the appearance of Farmer Hoggett and the little pig in the arena, all were overjoyed in the end when, without the least trouble, the little pig turned in a perfect performance and won the day. Story 40. It's quite common that a jury will convict a guy, but the conviction is overturned because the prosecution didn't present sufficient evidence of one of the elements of the offense. In an extremely rare version of this legal principle, My brother-in-law just had a case where the prosecution will forgot to present evidence proving the crime took place in the geographic jurisdiction, like county or state, of the court. Jurisdiction must be proven like any other element of a crime. The closest they got in this case was someone's testimony that it happened at home. Conviction reversed. Defendant is free to go. Story 41. When I clerked for my judge in law school, he told me a story about how the case before him involved a homeowner attempting to invalidate a restrictive covenant on his property that contained the restriction, "No animals to be raised on the property." Said homeowner had chickens or some other livestock and was being fined on the basis that the plain reading of the covenant required that it be invalidated on public policy grounds, that it prohibited homeowners from procreating and raising children. Story 42. Just knowing the rules qualifies a lawyer as knowing obscure law, since most lawyers don't bother to read all of them nor memorize them. Let's go off the record. No, I refuse, Madam Court Reporter. Continue taking everything down. I'm paying for the court reporter. I own this deposition. She'll stop when I say to stop. Well, actually, the rules of judicial administration and civil procedure both deal with the qualifications of a court reporter in this situation, and the rule specifically states that no one shall go off the record unless both parties consent to it. Here is the rule. Oh, Story 43. My sister's story. She was helping a teen who got in a minor car accident but still had to show up to court. The other side decided that he wasn't getting punished enough, so they tacked on a law from the 50s that anyone under 18 couldn't use a washer and dryer, completely unrelated to original case. The teen admitted to it when questioned. The judge agreed and sent the poor boy to juvenile hall for 3 months. He was only supposed to get his driver's license suspended. Story 44. I once used a Texas Supreme Court case from 1845 to prove the endurance of a particular legal precept. It was great because I was able to say that the particular rule survived despite Texas changing national governments 3 times in the intervening years. Republic of Texas, 1 Union, 2 Confederacy, 3 Union. Story 45. Not a weird law, but a badly written contract, if this counts. I had a friend who entered into a contract where one party contributed the down payment for a new house. The other would live in the house and make monthly payments, and then they'd split the gains, subject to a formula. When the house sold, the housing market tanked, and the latter party bailed, forcing the sale of the house, as stipulated in the contract. Because the contract didn't mention losses, the party who paid the down payment on the house got screwed. Story 46. I once prosecuted someone for violating an ordinance in Atlantic City that specified what color of pants he had to wear in order to push people around in a pushcart on the boardwalk. He had on black pants, but the ordinance required navy or khaki colors. Yes, that really happened. Story 47. There was this one time when I was in a fight with a cop, and when I got to court I claimed there is a lengthy legal precedent, Your Honor, going back to 1789, whereby a defendant can claim self-defense against an agent of the government, if that act is deemed a defense against tyranny, a defense of liberty. Judge didn't buy it. Story 48. Not really too obscure, but very nitpicky. Used State v. Piggott, N.C., as part of an arson defense. This case differentiates between scorched and burned, with the former being an insufficient factual basis for the charge. Also, I have used State v. Lanier, N.C., as part of a defense against the crime of going armed to the terror of the public. A guy rides a horse through a courthouse in that one. Story 49. California has some very specific penal code statutes. The one that comes to mind is Penal Code Section 286J, aka sodomy by fraud. The statute reads, any person who commits an act of sodomy where the victim submits under the belief that the person committing the act is someone known to the victim other than the accused, and this belief is induced by any artifice, pretense, or concealment practiced by the accused, with intent to induce the belief, shall be punished by imprisonment in the state prison for 3, 6, or 8 years. Story 50. In California, there are statements written into law that are like general guidelines as to how the law should work. They're called maxims of jurisprudence. These things were written in like 1880 and don't actually mean anything. I used a few to bolster a really weak argument. Here are a few. 3510. When the reason for a rule ceases, so should the rule itself. 3511. Where the reason is the same, the rule should be the same. 3512. One must not change his purpose to the injury of another. Story 51. You can impeach the declarant of a dying declaration with their criminal record just as if they had testified themselves. Cited a law that was from 1849, when Minnesota was still a territory. Story 52. Not a lawyer, but someone cited during an argument over whether a tomato is fruit or a vegetable. Legally, it's a vegetable. Story 53. A married couple drives on the highway and has an accident. Not much happens to the man who drove, but the woman is severely handicapped. The insurance pays the woman a lot of money as compensation. After a few months, the man says that he can't stand the situation anymore, that he sees his wife like this and has to care for her all the time, and that he wants a divorce. The court decides that the wife must give half of the money she received from the insurance company to the husband. Story 54. Whether a walkway can be categorized as a sidewalk under the meaning of a statute, and later, whether a driveway can be a walkway and therefore a sidewalk. Walkway okay, driveway not. Story 55. Not a lawyer and only barely on topic. Did you know there's a very real law in the books and still active in New Mexico that dictates that women are not allowed to go into public unshaven? Story 56. In 1976, somebody found an obscure Texas law that states that every company in Texas that sells beer, alcohol, 51% of that company's stockholders must live in Texas. I was working at Pizza Hut and Texas Liquor Control walked in and yanked our license and stopped us from selling beer. This went on for several months until a Texas lawyer figured out a way around it. His name was Gerald L. Anderson, and he set up a company that sold beer inside the franchised Pizza Huts in Texas. At night, when we made the cash deposits, we had one for Pizza Hut and one for Gerald's company. Pretty smart. Story 57. Recently, someone filed a motion based on champerty and maintenance in one of my cases. These are common law doctrines that basically say you can't transfer your right to sue someone without also transferring whatever gave you the right to sue. For example, if I want to sue a mechanic because he did bad repairs to my car but I don't have the money to sue, I can't transfer my right to sue to my rich friend without also transferring the car. Without getting too technical, I believe it's rarely used because it's already covered by the real party and interest requirement for standing. It's like insisting on saying "milady" instead of "miss." The person who filed the motion tends to file a lot of weird stuff that they don't understand, this being no exception. Story 58. Never used it, but it's in every property law text. Famous for holding, as a matter of law, the house is haunted. Story 59. Have an ongoing case on the issue of ademption and its exceptions. Ademption is basically a rule in estate law that if a gift under a will, typically property, is no longer owned by the deceased at the time of death, then the gift is addeemed, meaning that the person who is given the gift gets nothing. There is basically a big fight over the money from the sale of the house. The person who was given the house under the will wants the money from the sale of the house, even though the house itself is the only thing that was gifted and is no longer in the estate. The main problem is, there is basically no law on this in my state. There is one state Supreme Court case that discusses ademption and possible exceptions, and no other cases applying the exceptions discussed. So, we are relying on interpreting this case as well as cases from other jurisdictions, which as lawyers will tell you, if the case isn't binding on your court, you don't typically use it or discuss it. But you have to use what you can find. Story 60. I dated a woman for about 5 years. We broke up, but I didn't move out because even though we were not together, it was advantageous for both of us to continue to live together, combined income, and for a few years a friends with benefits situation, and I moved into the spare bedroom. I basically started paying her rent for the room each month, to help with bills. One night cops show up with a search warrant looking for one of her kids' friends. Now this pissed me off because 1. I am a severe insomniac. 2. They came in about 2 a.m. 3. The warrant was signed at around 1 p.m. 4. I had just fallen asleep when they came knocking. This royally pissed me off because there is one thing you don't do, and that is with my sleep. When they asked if they could search the house, she said, "Sure," because we knew the kid wasn't in the house. But remember, they pissed me off. I reminded them that as a rent payer and that my room was not a public traffic area, that legally they needed a separate search warrant to go in my room. I let them stand in the doorway with bedroom lights off, using a flashlight to look into the room. Now, had they not pissed me off, however, I would have let them know the kid was not in the house. He was in the clubhouse in the backyard. They never checked the backyard. Note, only reason, besides me off, that I was not forthcoming with where he was hiding was due to knowing what he was accused of was false claim, and the next day I managed to get video proving it. They ended up throwing the case out once I got the video to the DA. Story 61. Of course, IANL, but was taken to court over Sunday Observance Act 1780, was also other violations of UK licensing laws, but that was the most obscure one. Story 62. Not a lawyer, but a land surveyor. You would be surprised how much of the United States law concerning land ownership have their roots in the old feudal system and English common law. Most land that is freely bought and sold is said to be fee simple. In the Middle Ages, if you performed service, your fee, for the crown or your lord, you could be granted land that you could freely sell to someone else. Other kinds of deeds also date back to this period. A life estate was one that would revert back to the grantor upon the death of the grantee. Lastly, a feetail is land that can only be transferred by inheritance to a male heir. Feetail has been struck down by U.S. courts and is no longer enforceable. Story 63 Einl. But I was working for the Attorney General's Department in Australia as a computer nerd doing a proof-of-concept website for Australia's personal property securities, PPS law. Basically getting loans, liens against things like paintings like you can for a house car. We were using other Commonwealth countries' laws as a basis for the draft Australian law, mostly focused on Ontario. A number of paralegals were at a desk behind me discussing the Ontario law, and in it was a logical fallacy. In simple terms, the law states that ABCA, due to a lapsed then re-registered lien during a grace period, Ontario's Personal Property Security Act, RSO 1990, Chapter P10, Section 36. After diagramming it out for the paralegals, then again for the head lawyer for the AG's department, there were about a week and a half of intense discussions between the Australian and Canadian legal teams. So, I'm the reason Australia's PPS law doesn't allow for re-registration grace periods. Story 64. Not a lawyer, but a law student. We have moot court trials, basically fake cases, and I have pulled some weird stuff out of the book. In Colorado, you can get a DUI on a horse. It's not enforced at all, and I don't think it's still good law, but yeah. Don't get shit-faced and ride a horse. Or do and hire me when you get hurt. Story 65. I've never had cause to use this perjury case involving a grand jury investigation into smuggling, but I really wish I could. Story 66. In Danish tort and restitution law, there is a legal doctrine from a 17th century law regarding an employer's liability for the actions of his employees. It is very regularly used in court. Story 67. It is rather strange, but I find it fascinating. An ancient homeowners association is a good comparison. I wonder how many academics I could give headaches to if I referred to it as that. Also, what's a skip?